Plaintiff Jane Doe's reply in support of motion for protective order governing public commentary by trial participants. Oh, they want to do a gag order on me, so I'm not allowed to talk about it, which is fucking retarded, given... I will write it, man. This will be my final manifesto. I will do a full write-up on this entire thing from start to finish, because nobody will cover this unless I write it all up cleanly, just in terms of like all the unhinged, crazy, depraved behavior that the other side has done in the course of this whole case. But comes now Plaintiff Jane Doe by and through undersigned counsel, and hereby submits her reply in support of her motion for protective order governing public commentary by trial participants, and respectfully states as follows. Defendant's opposition to plaintiff's motion grossly mischaracterizes the nature of the relief sought, the applicable legal standards, and the relevant facts. Plaintiff does not seek to muzzle the defendant, nor does she seek to prevent him from defending himself in court. Yeah, no Sherlock Holmes. Rather, plaintiff seeks a narrowly tailored protective order that applies equally to all trial participants. Well, because she's already gotten her bullshit out there, but okay. And is only intended to curb the ongoing harassment, intimidation, and misrepresentation that threatens the integrity of these proceedings and deter witness participation. See proposed protective order, blah, blah, blah. Okay. The record is clear. Multiple potential witnesses have withdrawn their willingness to testify due to fear of retaliation and doxing by defendant and his followers. There's never been any evidence of this submitted, ever, but okay. Defendant has made explicit threats of violence against plaintiff's witnesses. Again, Queeman and Dristigal are not witnesses in this case, so it has nothing to do with that at all, but I guess you could just lie over and over and over and over and over and over and over again in every single motion, I guess, that you file, but okay. Disparaged plaintiff, true. Her witnesses, kind of true. But I mean, like, all of them are actively and continually chatting in Dristigal's Discord server. Like, these are the least secretive people ever. Her witnesses and her attorneys, in repugnant terms, get over yourself, who the fuck cares, disclosed the sealed identity of plaintiff. Her name was literally posted on her GiveSendGo when she initially published it. But also her name was used the same day she filed for a protective order. After that, I haven't done it at all. And I've removed it when they've asked, but I like how she keeps saying this over and over again. And published private communications on platforms with hundreds of thousands of viewers. Yeah, this isn't illegal. There's not a law against this. But defendant claims that plaintiff continues to attack and malign Bunnell online, but provides no evidentiary support, nor can he, for this false contention. Defendant's opposition further asserts that plaintiff's public statements include vitriolic attacks on Bunnell and his attorneys, but again provides no evidentiary support, nor can he, for this false statement. I mean, she tweeted about the denims. No? Do they just say that doesn't count here? Plaintiff requests that these unsupported and false statements by defendant be stricken from the record pursuant to Rule 12F of the Federal Rules of Civil Procedure. Plaintiff also requests that the court admonish defendant's counsel for litigating in bad faith and or impose sanctions pursuant to Rule 11. I see that it looks like they have somebody else writing these now, because this one is formatted quite a bit differently than the other ones. I wonder if they hired somebody else or if one of the other lawyers are writing these now. Are you not allowed to say her username? Pixie? I can say Pixie, I'm just not supposed to use her real name. This is retarded, though. Like, when people do these cases with protective orders because they don't want to be known or they don't want to be associated publicly with the case, Pixie loves the public association. She wants to be publicly associated. She just doesn't want to be quote unquote doxed, which is like a child's term that you use online for not wanting people to know your name, but it shouldn't really apply here in a court term. Retroactively looking back, I wish we would have fought the initial protective order. I don't know if there's a likelihood of success on winning there, but maybe it would just be a waste of money. If I was representing myself, I would have fought the protective order. How are you going to ask for a protective order when you've already publicized all of this online and wrote a Substack and everything else about it? It's an exceptional use of a protective order. And if you look at any of the other cases around this, like nothing is ever done like this. Like this is just fucking wild. Instead, even the evidence submitted by defendant shows that plaintiff's limited public updates, in contrast, have been respectful and have not disclosed confidential information, threatened any party, or deterred any participant. Rather, they seek to encourage participants. How do I even get participants on my side of this? I mean, I don't know what. Why would the person not being protected help you, Destiny? There is a public interest to court proceedings being public. There's a public interest to people's names and reputation. Like if you're filing stuff in public court, you're making a claim. You're basically saying that I think that I've been injured in such a way that I think the state needs to intervene and grant me relief for this particular thing. And all of us have a public interest in having access to the records on that. This is why all the court filings are public. Protective orders and things protecting names should be exceptional, and they are exceptional rather than the rule for these types of things. But defendant's opposition ignores the governing standard, the substantial likelihood of material prejudice test set forth in Gentile v. State Bar of Nevada, which courts in this district routinely apply. The proposed protective order meets this standard and is the least restrictive means of protecting the judicial process. I'm not going to bother reading all the underlying cases. Every time I do, they're horrendously miscited, but I don't know if it is or isn't here. Wait, if they are saying you provide no proof of her speaking out and lying, why not just submit the tweet to the court as evidence or whatever? We probably did in the last motion, but these guys just say whatever. They just lie over and over and over again. And until the judge starts ruling on things, I mean, I think we're supposed to get some rulings on these motions, hopefully within a week, but the big one will be what the magistrate judge recommends in regards to the preliminary injunction. And then hopefully I get approval to go over that transcript publicly. Contrary to defendant's framing, the proposed protective order is not an asymmetric gag order. It explicitly applies to all trial participants, including plaintiff. Didn't she imply that your lawyer was a rape defender on Twitter? Wouldn't that be an example of her attacking your lawyers? Yeah, I don't remember if Andrew included that in a briefing or not, but yeah, I think she did tweet that initially, that Destiny got the lawyer who defended, these guys or whatever. Are your counsel or you planning to respond to these motions? No, there's a name for it when you have a right of reply. Where are my lawyer people at? What's it called? Like a right to reply. Like we've already given our response to their motion, and I think this is their response to our response to the motion or something. Let me check. Hold on. We're not entitled to file a surreply. SUR-reply. I'm guessing is like a required response to a thing. So we don't have a right to respond to the response, basically. You should explain why they sealed it. For layman's, it looks like it's the court siding with them because they have reasonable arguments to seal it rather than it being standard operating procedure. Well, they haven't sealed it yet. It's just sealed until the judge makes a ruling on it. I think generally when you request things to be sealed, they'll be sealed until the judge makes a ruling on it, because if it's open and then they make a ruling to seal it, it kind of defeats the purpose, right? But I'm pretty sure that I think it would be exceptional if they agreed to seal that after it was already in open court and they really didn't have any good legal arguments for it. So it explicitly applies to all trial participants, including plaintiff, and prohibits only that public commentary which disparages, threatens, or intimidates parties, counsel, or witnesses. Disparages? Like what? I can't say, like it's so crazy. Discloses sealed identities or confidential attorney communications. You don't need an order for this. It's already not okay to disclose sealed identities or confidential communications. That's why the identities are sealed, and that's why these communications are, if they're confidential. So I don't know why you would ask for an order about that. Misrepresents legal filings or court orders. Are you allowed to be retarded? If you think I'm incorrect about how I'm representing something, then fine. But I mean, like, I want to protect order against misrepresenting. Like, what does that even mean? Okay, but discloses sensitive personal allegations or private details of the parties or witnesses. Like, all of these people are constantly talking about me in Justical Server. Like, I can't say anything about any of these people ever now. And also it applies to every single person, like potential witness. I don't even know what a potential witness is in this case. Apparently anybody can be a witness ever. Trump could jump onto this case, I guess. Such restrictions are well within constitutional bounds. Defendant's reliance on this case and this case for his contention that the proposed order violates his First Amendment rights is misplaced. Both cases are inappropriate or inopposite, since they involve broad restraints on the press, not on trial participants. The Supreme Court and other courts of appeals have recognized a distinction between participants in the litigation and strangers to it, pursuant to which gag orders on trial participants are evaluated under a less stringent standard than gag orders on the press. Oh, cute. Are they actually trying to read through the cases now and cite them in their motions? Am I inspiring them on stream to do their job? Good job. I'm too lazy to dig through these cases, though, so. Nebraska Press is further distinguishable because the prior restraint was struck down due to the lower court's failure to consider less restrictive means or measures. CBSA is also distinguishable because 1, There was no evidence of actual or potential prejudice to the proceedings. And 2, it was a white-collar crime case where the courts have found a less significant danger of prejudice compared to cases involving lurid subject matter, which carry a more significant danger of prejudice. In contrast here, 1, less restrictive measures would not suffice. And 2, plaintiff has presented evidence of actual and potential prejudice. And 3, the lurid subject matter of this case carries a high risk of prejudice. 3, plaintiff has demonstrated substantial likelihood of material prejudice. Defendant contends that plaintiff has not demonstrated a substantial likelihood of prejudice to the proceedings because 1, this case is an early pre-discovery posture, and 2, plaintiff has only demonstrated speculative harm or generalized discomfort. Both of these arguments fail. First, this case is not in an early pre-discovery posture. Discovery has already commenced. Written discovery requests have already been exchanged by the parties, and responses are due. However, the parties agreed to await the court's ruling on plaintiff's motion for a protective order governing discovery before exchanging responses and documents. I don't know if there's like a formal distinguishing thing between pre-discovery and discovery and whatever. We haven't turned over any discovery yet because we're waiting for the court to rule on some motion, so I don't know, but... Moreover, the case law relied on by defendant in support of the argument is inopposite. In Calhoun v. Invention Submission Corp., the defendant requested that sanctions be imposed on plaintiff and her counsel for posting the allegations of the complaint on a website. Discovery had not yet commenced and no trial date is scheduled, let alone on the horizon. Here, in contrast, plaintiff has not moved for sanctions but for a protective order. And 2, the defendant has not just posted the allegations of the complaint, but instead has harassed and vilified plaintiff, witnesses, and her counsel, and threatened bodily harm to witnesses. Okay. And discovery has commenced and a trial date has been set. Nor is Constant v. Cosby helpful to defendant since the court entered an order imposing limits on attorney speech. Second, defendant's argument that plaintiff has shown only speculative harm is clearly belied by the record. As detailed in plaintiff's motion and supporting declaration, defendant has publicly threatened to kill potential witnesses. I'd kill them if I could. I want someone to kill named witnesses. Again, Jistical and Queeman are not witnesses in this case, but as long as Kiwi Farms continues to post it, I guess they'll continue to copy paste it. I don't know how long you can just lie about something over and over and over and over and over and over and over again. Maybe this will just be the lie that they carry if they get there all the way to trial. Maybe, who knows? Disclosed plaintiff's legal name in violation of the court's anonymity order. Again, this happened before the protective order came out. Since then, not disclosed the person's name. And clearly the plaintiff didn't really care because they withheld that like the name was in the video for months so that they could have it in a motion, 6 months into the case, I guess. But okay. Published confidential meet and confer communications. Published confidential. I don't even know if these communications are supposed to be considered confidential, but okay. And engaged in a pattern of disparagement and ridicule directed at plaintiff, her witnesses, and prospective witnesses, and plaintiff's counsel. I mean, plaintiff has done the same to me. I mean, like when you've made a public Substack that is unhinged and contains like a fuck ton of lies in it, and then you cry that I think that you're a crazy person or whatever, like this is just so ridiculous, but whatever. Plaintiff provided specifics regarding Bonnell's vitriolic public commentary and prospective witnesses' reactions to it. Where? I went through all of the declarations, and I think I only saw one person who said something, but it wasn't even... yeah, I don't know where these filings are. Somebody can link it if it's there somewhere, I guess. See, ECF 44, 84.1 and 84.4. I guess we can look. 84.1 and 84.4. Plaintiff provided specifics regarding Bonnell's vitriolic public commentary and prospective witnesses' reaction to it. This is 84.1. Hi, Jane Doe. Oh, so this is just Pixie. I'm over 18 years of age. I'm guessing. I come to provide testimony. Oh, the personal knowledge. This is so fucking retarded, dude. She's still running with this is just hearsay. This is double hearsay. One of the individuals whose screen name was blank. When was this filed? I don't even remember when this was filed. June 2nd. Oh, right before the hearing. So her evidence of people feeling threatened by me are one of these individuals whose name was censored told me that the defendant sent the video depicting me to their sister just a few months ago. This individual and their sister, as well as other individuals who had initially contacted me, completely deleted their accounts after Destiny posted his video on the YouTube entitled Destiny Addresses Lawsuit. So keep in mind, just to be aware of what this incompetent retard is doing, right? Is she's filed a lawsuit against me and she didn't get statements, declarations, affidavits from any of the accounts that supposedly DM'd her. Like, what the fuck is, how fucking stupid do you have to be? What are you even doing at this point? Why would you not get a single one of these in writing? Why would you not get any names or any statements or verify that any of this information is even fucking true? But then she keeps throwing it over and over and over again in all of her, like, hello? In this video, defendant further violates my privacy by publishing to his almost 1 million followers out of context private messages. The three women that provided declarations under seal in support of plaintiff's motion for preliminary injunction expressed fear of being publicly targeted or doxxed. This is hearsay. Make them submit an affidavit or declaration saying it. You can't just speak for everybody. That's not how this works, little bro. You can't just say, like, somebody else said this. You have to, they need to sign that. They need to attest to that under oath. They have to sign a thing saying that I promise this is my sworn and true statement. Because maybe you're misinterpreting things, or maybe they say they wouldn't say that. I don't know why they keep doing this. I know why. It's because it's malicious is the actual answer. But the three women that provided declarations under seal in support of plaintiff's motion for preliminary injunction expressed fear of being publicly targeted or doxxed by defendant or his followers, and indicated they were unwilling to participate in discovery or testify unless their identities remained confidential. For this reason, the witness declarations were filed under seal. Like, that's not in any of the declarations. But besides these three witnesses, there are 4 additional witnesses I have contact with, but they told me that they are afraid of speaking out or testifying against the defendant because of his likely retaliation and harassment. Attached here, too, as Exhibit A, is a true and correct copy of one of these witnesses named, who has communicated to me her fear of defendant. Desi tried to repeatedly dox one of these witnesses, whose screen name is blank, after he publicly expressed his support for me. That's not a witness. Somebody who expressed support is not a witness. The potential witness will not testify to pertinent information regarding the case unless his information can be protected. Blank has expressed fear of providing any further information after the defendant publicly called for his death on the defendant's YouTube channel. Wait, have I? Or are they talking about on Willie Mack's YouTube channel? I'm pretty sure that was the thing that Willie Mack published of me. I don't think I ever said any of, I don't remember if I did or not. I don't remember, to be honest, but the 3 other potential witnesses also believe that the defendant has committed crimes against them by disclosing intimate images of them. The 3 other potential witnesses are your 3 current witnesses, but they are afraid of pursuing legal action because of how he's publicly harassed and insulted me and anyone who has supported me, including my counsel. 3 of these witnesses have expressed to me their fear that their physical well-being could even put at risk if they attempt to pursue justice. Like, how does this even make sense? If you file it under seal, I still get access to the name. You think I'm willing to have these people, like, physically attacked? But if you file it under seal, I won't do that? Like, what? Why am I Destiny in the court filings and not Steven or something? They go back and forth because they're mentally retarded. Almost every individual I have communicated with expressed not only their disgust for defendant's actions, but also their reluctance to speak out publicly due to their concern and fear of defendant retaliating against them. Wow. Wasn't that statement about Justical before they were mentioned as potential witnesses in this case anyway? Yes, yeah. It was like months ago when Willie Mack interviewed me for a YouTube video. Yes. And it wasn't on my channel. It was on Willie Mack's or whatever. Oh, this text message. I'm sorry. I just remember this one. My bad. They did submit this. I just forgot about it because this is the most obviously faked message I've ever seen in my entire life. Stephen Bonnell has abused his position of power and community to gain favor and harass people in the past. I find his actions deplorable and terrifying. I will never feel comfortable being a witness in this case against Stephen unless my identity is protected. I fear for my family, friends, and my current and future careers. Without protection, I am almost certain I will receive harassment and doxing from his community. Nice, based. And it's the first text message they got from this person. Good one. Okay, so those are the 2 things that they submitted for evidence of prospective witnesses being afraid. Gotcha. Wait, surely there is some official affidavit from this person that they should have filed instead of this weird written text message screenshot? No, because they don't have any witnesses for this case, because this entire thing is fucking bullshit, and they know it's fucking bullshit, which is why all of this is like either hearsay from Pixie. Oh, it's 1 through 4, not just because this is 81-4 to 81-4-4. I see. It's just I don't have money for a lawyer or anything. Once he knows my name or something, I'm afraid he's going to harass me or get others to do so. And then, like, what? Justical doesn't even have any info. What the? Like, what is, he doesn't even have any information relevant to this case. What is the claim that I'm sending him video? Like, we're jerk buddies? Like, what? It's so fucking crazy. But, okay. My jerkmate duo, yeah. Contrary to defendant's blithe contention that plaintiff failed to tie her alleged harm to any specific statements or conduct attributed to Bonnell, the evidence presented shows that defendant's actions have caused multiple prospective witnesses to refuse participation and has hindered evidence gathering and thus prejudiced these proceedings. When was my first YouTube video response published? What was the date on that? Wait, I thought there was a YouTube video linked in here. Am I crazy? Is the link just not in a different color? Purpose. Destiny addresses his lawsuit. This is February 20th. That text message was on January 22nd. Had I said anything publicly about this yet? How are my statements in the future scaring defendants in the past? Because that text message that they cited here, first of all, this just was not relevant to this case at all. He has no discoverable, there's nothing relevant at all. This person said that they were afraid of me on January 22nd. Had I even said anything yet about this? When did Pixie drop her thing on January 20th? Like, they're already afraid? Like, well, seriously? Okay. Time moves in one direction. Don't forget. Oh, she's the one that linked my YouTube video on February 20th. Okay. The evidence presented has shown that defendant's actions have caused multiple prospective witnesses to refuse participation and has hindered evidence gathering and thus prejudiced these proceedings because they have no evidence. So they have to evidence gather after making the public Substack and after filing the lawsuit in the hopes, they're like praying that somebody comes forward with some magical piece of evidence. But okay. This is precisely the kind of conduct that the Gentile standard was designed to address. See also Shepard v. Maxwell. Defendant falsely argues that plaintiff's evidence is vague and unsubstantiated and relied on unnamed and or yet unidentified witnesses. This is true. In fact, plaintiff's declaration and supporting evidence show that she specifically identified 4 potential witnesses that have communicated their reluctance to participate due to their fear of defendants' doxing and vicious attacks. The ECF 85. What is even June. I'm just curious. I should have unredacted versions of these, right? Is that your fault if they are afraid of you? Don't they need to show actual proof that something that happened they testified? Kind of, yeah, it has to be, it can't be generalized. It has to be like specific and traceable or some bullshit. Okay, wait, what are these? Hold on. Give me a sec, I'm sorry. Dun, 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 dun. Wait, not this. They sent me, what they sent, the versions that they sent me were redacted? So I don't even know personally who these, what the fuck? Seriously? I have the same document. Okay. So there are people who are afraid of me and I don't even know who, okay, based. Absolutely based. Oh, this image is redacted, so I don't know that one. This is redacted, I don't know that one. Oh, and that message is redacted. Cool, all right, cool, that's good. Based. Okay. So I don't know, I have no further information. I wouldn't be able to tell you guys publicly. It'd be nice to know for my own case, so I could like defend myself, but that's cool, that's fine. I don't have to know any of it, I guess. In fact, plaintiff's declaration supporting evidence show that she specifically identified 4 potential witnesses. What does that even mean? That have communicated their reluctance to participate due to their fear of defendants' doxing and vicious attacks. The names of these witnesses were redacted in the declaration, and the evidence submitted in a motion for filing. So it was submitted. Moreover, the 3 witnesses who have agreed to testify and provided declarations would only do so under seal due to their fear of defendants' retaliation. See, but they leaked basically the names for all these people anyway, so a good one. Also, I read all of these declarations. I think only one of them mentioned anything about being afraid or wanting to remain anonymous. The declaration of Brooke, she doesn't say anything about being afraid or wanting to be anonymous. That was the first one that was submitted. The declaration of Abby MC, she says that she doesn't want her real name revealed, yet they leaked and they keep referring to her over and over again as Abby MC, which is stupid. For docket entry 49-4, they're not even a witness to this case. I don't even know what this person is doing here. None of the witnesses are even relevant to this case. So like, here's an anonymous witness. I am over the age, or I'm above the age of 18 and competent to provide testimony under oath. I have personal knowledge of matters therein, blah, blah, blah. Okay. Beginning on May 25th, 2024, I began exchanging messages with the defendant, Stephen K. Bonnell, on Instagram, subsequently on Discord, where I engaged with him as a fan. Shortly thereafter, beginning late May 2024, our conversations progressed and became more personal. We began exchanging private sexual content with one another, and Destiny shared graphic sexual content of himself alone, as well as graphic content depicting others, himself and other individuals engaging in sexual acts. Destiny shared some of these videos with me directly via Discord messages, but the majority of them were shared through a Google Drive link, which he sent me via Discord for the first time on or about June 2024. The graphic sexual content that he shared with me was mostly digital videos, although some were digital photographs as well. I ceased contact with Destiny on or about November 5th, 2024. I subsequently became aware of the allegations that had been online leaks of Destiny engaging in sexual acts with individuals on or about January 21st, 2025. I became aware of Jane Doe's post on Twitter, where she alleged in part that Destiny had shared the videos of them engaging in sexual acts without her consent. Shortly thereafter, I reached out to Jane Doe on Twitter and informed her that I was concerned that Destiny had been sharing private sexual content without consent, stating in part that, quote, back in spring/summer, he had sent me videos of other girls. I assumed that he had consent for these, but I realized he likely didn't. Although I had access to the messages between Destiny and myself at this point, sometime afterward, I discovered that Destiny deleted the message between him and him in Discord, and subsequently discovered that I no longer had access to the Google Drive containing the graphic sexual content, which we deleted. This is like, what is this? This person isn't even claiming that they got anything from me of Pixie, number one. And then number two, they don't even have any context on like, oh, well, I think these other videos weren't okay. Like, what even is this? It's not even relevant to this case. Let's see, that's one. And then this is their other quote unquote witness. On or about April 2022, I reached out to the defendant, Stephen K. Bonnell II, via Twitter. Shortly thereafter, we get to arrange together in blank, where we began a sexual relationship. Thereafter, Destiny and I remained in contact. I also became friendly with his wife at the time, Melina. At some point, Destiny asked me if I was comfortable with him sharing videos or pictures of sexual content involving himself, as well as himself and his wife. I told him that I did consent to him sharing these videos with me. Thereafter, we began sharing pictures and videos of sexual nature with one another. Most videos Destiny sent with him alone, although at least one of these videos included himself and his wife. On or about mid to late April 2023, Destiny invited me to blank, where he was staying briefly while at blank. Destiny recorded himself and I engaging in sexual acts. Recordings made with my consent, and I authorized Destiny to share the recordings with his wife exclusively. I did not authorize Destiny to share these recordings with anyone else or to otherwise make them public. Thereafter, I continued to communicate with Destiny online. In late November 2024, I was harassed by multiple individuals while on Discord who informed me that a video of Destiny and myself had leaked online. After confirming this was the case, I confronted Destiny. I don't know if I'm allowed to speak to our. Well, I'm not revealing who this is. So, who told me that he was sorry that any videos involving myself had leaked because of him. Destiny also told me that he only shared this content with a single individual who went by the screen name Rose. I don't believe that's true. Following this conversation, I received messages from multiple women on Discord and Twitter who'd been in contact with Destiny, who told me that Destiny had shared with them sexual content depicting myself as well as others. Sometime after the November 29th leaks, I discovered that Destiny deleted messages between himself and I related to the foregoing. So the ironic thing is, and I can bring this up right now, but I won't because I don't want to reveal what it is. They deleted their messages with me, which is funny because we had talked after this and we're still friends after this. And then I looked at my Discord one day and I noticed, oh shit, they've deleted all of their messages with me. But I also found out that they were hanging out in a certain Justical Discord. But also, regardless of all of that, this has nothing to do with this case. What? Like, why is this even here? Like, this person has nothing related to the actual complaint filed by Pixie. This person's not making any allegation. Like, there's literally no point for this even being here. They have so much random So the fact that they're trying to say that, oh my God, these witnesses are intimidated, they're not even witnesses. These aren't witnesses to this case. These are like literally, these are like random statements that you've collected from people to just throw on that literally have nothing to do with any of this. Like, I don't even know what I can respond to for these. Like, it's not even the subject matter here. But defendant's attempts to ignore or downplay the harm he is causing falls flat in the face of the overwhelming evidence presented. Defendant declared the following about two potential witnesses. Potential witnesses? That's why people like Jessica and Queenman, if I could put their fucking balls in a vice and crush them and then feed it to them and then slice their dick off and kill them. See blank at minute 56:42. When did I even do this interview? I feel like this interview was done in like January or February. Does Willie say? 1, this interview was done a long time ago. 2, this isn't even published on my channel. 3, these people are not parties to this case. These people are not witnesses. They have nothing to do with any of this. And none of my commentary about them here has anything to do with this case. So it's like, it's so fucking stupid. This commentary is not merely uncomfortable or critical, as defendant absurdly claims, but rather violent and extremely prejudicial. This commentary undeniably deters witness cooperation and undermines the fair administration of justice. Both of these people, Queenman and Gisticle, have talked about me incessantly for months after. Clearly, they're not deterred, and clearly they're not afraid. So, like, what are we even talking about here? Like, these people talk about me almost daily. In another of defendant's income-producing streams, I love how they say that, he recently accused the plaintiff and her counsel of fabricating evidence. I love also how we're being honest now. Thank you. We're just taking straight rips from Kiwi Farms. https://uploads.kiwifarms.st data/video/ also their links are broken half the time. So I don't even know. I'm sure the judge will figure it out. Like actually in clown show that they're literally just control F5ing my Kiwi Farms thread every day for their next legal argument. But that's cool to just waste my time and destroy my life and my reputation and everything else over this. That's nice. Thank God my prior circle of friends is respectful enough, though, to not make any commentary about this at all on the other side of it, but only on mine. Very spine-possessing people. Defendant tells his hundreds of thousands of followers, I bet this is a fake message, and clearly opposing counsel and plaintiff are dumb enough to fake this in the stupidest way possible. Oh, is that about the declaration that I'd already read? I think it is a fake message. I don't believe it. I don't believe it. And I'll say it again. Put me in your next filing. Defendant has failed to refute the overwhelming evidence consisting of his vitriolic and threatening public commentary, its impact on witness participation, and its actual and ongoing harm to these proceedings. To allow defendant to continue with his unfettered public commentary will jeopardize the integrity of these proceedings and impair plaintiff's right to present witnesses. Saying all of this while even temporarily sealing the transcript where we spoke in front of a judge is the ultimate in cuckoldry, in spineless weaponization of the legal system, and in weaponizing the white woman status to seal the transcript where we're both under oath. And we have to answer honestly in front of a judge. And it's not just the unhinged, deranged and incoherent ramblings of a schizo lunatic that can apply to either plaintiff or her counsel. Like it's subhuman behavior. Like protective order is the least restrictive means. Defendants contends that voir dire, I don't know what that means. Good job.
Voir dire.
Voir dire, a preliminary examination of a witness or a juror by a judge or counsel. Wait, wasn't this a public hearing? How can they make it private? It was public. I don't think they can make it private. Hopefully the judge should rule against that, but we have to wait for the judge to rule on it. Defendant contends that voir dire, that's what he said, right?
Voir dire.
Voir dire. Contends that voir dire, jury instructions or confidentiality orders are sufficient alternatives. They are not. This case is still in the pre-trial phase, and voir dire does nothing to address ongoing harm to witnesses, witness intimidation, and or the risk of future disclosures of confidential material. The proposed order is narrowly drawn, addresses only the harmful conduct already documented, and preserves all rights to file pleadings and argue the case in court. Moreover, although protective orders governing discovery are standard in cases such as the instant one involving sensitive personal information, not only did defendant refuse to cooperate with plaintiff's efforts towards a stipulated confidentiality agreement, but he has actually opposed plaintiff's motion for a protective order governing discovery. And although that protective order would serve to protect confidential, sensitive information of the parties, it would not prevent the defendant from continuing his public doxing and threatening and false commentary. Defendant contends that the proposed protective order would somehow restrict or impact his right to defend himself. The narrowly tailored order does no such thing unless his right to defense involves attacking and threatening plaintiff, witnesses, and counsel. It does not. The First Amendment does not protect speech that interferes with the fair administration of justice. The fair administration of justice, my God. Defendant's attempts to construe plaintiff's motion as nothing more than an attempt to restrict public access to this court is nonsensical. The pleadings are available to the public, and nothing in the proposed order seeks to alter public access. This is literally what a seal does. Or unless you're talking about that's what a protective order, if they're filing to protect names and stuff, this is literally what it does, is to keep stuff off the public record. But okay. Say the judge sees through this bullshit. Is it possible for the plaintiff to be forced to do like a full public retraction or something? No, they would never. I would have to like counter seal or something like that, or counter sue or something. But the applicable precedent supports the entry of the narrowly tailored proposed protective order. Defendant fails to distinguish the controlling precedent relied on by plaintiff in her motion. Indeed, the opposition fails to even address or attempt to distinguish the primary case relied on by plaintiff Hernandez, in which the Southern District of Florida imposed restrictions on trial participant speech after finding likelihood of prejudice and no less restrictive means. Defendant's opposition fails to address the critical distinction between constitutionally protected commentary and targeted speech that threatens the integrity of judicial proceedings. Do you get the vibe that Doe's lawyer hates you personally because she's seen all your negative comments? I think they do because it's a personal friend. That's what I'm pretty sure it's a personal family friend. particularly through the intimidation or silencing of witnesses. Restrictions on extrajudicial statements by trial participants are both lawful and necessary. The evidence submitted showing the defendant has publicly threatened, disparaged, and attempted to dox potential, specifically identifiable witnesses demonstrates precisely the kind of conduct these authorities contemplate. The Southern District of Florida recognized in Hernandez, when witness participation is chilled by public attacks, courts may impose narrowly tailored speech restrictions as the least restrictive means of safeguarding the proceedings. This motion does not seek to silence one party or prevent any valid defense. It is about protecting vulnerable witnesses from intimidation and ensuring that testimony may proceed from fear or retaliation. Defendant misleadingly claims that this is a low-profile civil dispute. Opposing thing, page 11. It is not. I wonder what this was in the context of. I mean, it's a civil case. It's not like a huge corporate litigation thing, and it's not a criminal case. But there have been numerous press releases and articles about it, and hundreds of thousands of people tune into defendant's streaming platforms to hear his distorted version of the proceedings and allegations as I just read the court documents, but okay. And to listen to and encourage with financial remuneration his abuse of the plaintiff, her witnesses, and her counsel. They keep bringing this up over and over and over again, despite the fact that I've lost money on this. And they know that too, because that was also part of our hearing, which is probably another reason why they want to keep it sealed. I think this woman could have had law school paid for, but went this run instead. I think she already took the LSAT one, so she probably took it and got like a 70 on it and was like, F me. We'll just play lawyer instead. This is not the run-of-the-mill civil dispute, but rather a high-profile dispute with lurid content and a trial participant, the defendant, who has his own streaming platforms with almost 1 million followers. This scenario only exacerbates the high risk of prejudice to these proceedings due to defendants' threatening, harassing, and false commentary. Plaintiff's limited public comments do not warrant denial of the order. Defendant argues that plaintiff's own public statements undermine her request. This is false equivalence. Plaintiff's posts consist of announcements of procedural rulings, for example, sealing of witness identities, a fundraising effort. Defendant should certainly not object to plaintiff's GoFundMe page. It's a GiveSendGo page. Got him. Since he has been profiting immensely from this case by streaming on a regular basis about it. My lawyer's fees are up to about $200,000 so far. I have not made that much money talking about this case. Not to mention canceled shows, reputational harm that will likely never go away, and everything else involved in this. But that's cute to say this over and over again. They really, really, really like to run with this argument. This profit revenue is evidenced by the number of views on his videos about the case and the number of comments and questions. For example, streamers such as defendant receive revenue from their YouTube channels based on memberships, AdSense revenue. Streamer gets paid based on number of users viewing ads, and super chats. The user pays to have his or her message highlighted in the live chat during a stream. The more money is paid, the more likely the streamer will read the message aloud or respond to the question. A fundraising effort in general calls for information relevant to her case or witnesses. Again, I'm sorry, little bro, but if you want to be a big boy or big girl and you want to be an adult and you want to file a court case, then you should file the case with your affidavits and everything in hand. If you're filing a case with nothing on pure lies and copium, which is what she's done, and she knows that she's done that, and then you're praying to God that after attacking my reputation as hard as you can, after going after everything I have as hard as you can, praying that somebody comes forward to substantiate your bullshit case, that's on you for being a fucking retard. Sorry. CCF 992 to 95. In stark contrast to the defendant, none of plaintiff's posts involve threats, harassment, vilification, saying that I lying about her age over and over again, saying that she was 19, saying that I purposefully wanted my sexual content to be leaked and spread all over the fucking internet. All of that, none of that was vilification. Seriously? Exposure of sealed identity. And again, it wasn't sealed yet. It was the same day, but or publication of confidential materials. I don't know what they're even referring to there. Plaintiff has not doxed, intimidated, or mocked any party or witness. There is no evidence that plaintiff's limited posts have deterred witness participation or jeopardized trial fairness, while there is ample evidence that defendant's posts have done so. See above. Further declarations of people that aren't even relevant to this case based. Defendant distorts the request for relief by arguing that the post-protective order would allow plaintiff to broadcast her message while silencing opposition, but it is patently clear that the request for relief would apply equally to both plaintiff and defendant and seeks only to silence threatening, harassing, and false commentary. See ECF 84.5. I forget, did their thing allow them for her to keep her stupid fucking GoFundMe up, her GiveSendGo up? Is it just me, or does this feel like it hinges entirely on the premise that you leaked everything to Kiwi Farms intentionally, despite you being the one most directly? Yes, it does. I think that's one of the overarching narratives that kind of got destroyed at the hearing, which I think is another one of the reasons why they wanted that transcript sealed. And it was funny. This is one of the things that I was like happy about is I could see because the judge kept asking questions where he's like, wait, so he published that to Kiwi Farms? And then she'd be like, well, no, someone else. And it's like, oh, okay. Or when she was talking about, when I found out that she'd sent all of our videos to her ex, and the judge was like, wait, he sent all of your guys' videos to your ex-boyfriend? And then she's like, no, I sent our videos to my ex. I was like, oh. Like he was, like I could see the lights turning on the judge, and he was like, wait, what? Or like wait, really? But hopefully we can read the transcript soon. Prohibited content that harasses, threatens, or intimidates the parties, or publicizes or repeats any sensitive personal allegations or private details underlying the claims, publicizes or repeats any confidential settlement discussions or communications protected under Federal Rules of Procedure 408. You're going to wait, is this even real? Protective order. And part of it is misrepresents or mischaracterizes the content of legal filings. What? Rule 408, compromised offers and negotiations. Prohibited uses. Evidence of the following is not admissible on behalf of any party, either to prove or disprove the validity or amount of a disputed claim, or to impeach by a prior inconsistent statement or condition, furnishing, promising, or offering, or accepting, promising, offer a valuable consideration and compromising or attempting to compromise the claim and conduct or a statement made during compromised negotiations about the claim, except when offered in a criminal exception. This is court me. Wait, what? I'm sorry, am I not understanding this? This Federal Rule of Civil Procedure sounds like it has to do with whether or not like things that you say during negotiations for like a settlement are admissible as evidence towards the validity of the claim or whatever. This doesn't sound like it has anything to do with protecting communications. Am I looking up the correct Federal Rules of Civil Procedure 408? Compromise offers and okay, I'll just keep reading. I'm sorry. As a matter of general agreement, evidence of an offer to compromise a claim is not receivable in evidence as an admission of, as the case may be. Okay, yeah, this makes sense. So like for instance, if I like this makes sense. Let's say that I'm like, okay, fuck it. Let's settle. Let's have a discussion, right? We've had discussions on settlement. Oh, I'm leaking more information. Let's say that I was to say, okay, fine, I'm going to settle. I'll give you X dollars. We make a statement or whatever, and then that's fine, right? And you're like, and then they're like, no. And then let's say that like later on in the case, they file. And by the way, I know that he's guilty of this because when we were having discussions of settlement, he offered me X amount of dollars, right? That's what it sounds like Rule 408 is governing. Not like evidence, like you can't submit evidence to prove or disprove the validity or amount of a disputed claim based on the settlement discussions. As with evidence of subsequent remedial measures dealt with in Rule 407, exclusion may be based on two grounds. One, the evidence is irrelevant since the offer may be motivated by a desire for peace rather than from any concession of weakness position. Validity was two, a more consistently impressive ground is promotion of the public policy favoring the compromise and settlement of disputes, while the rules are ordinarily phrased in terms of offers or compromise. I'm sorry. Okay, this is why I don't read reading their citations is painful. I don't know why this was cited here. Sorry, 20 euros. Mandami has said that he wants the city to run supermarkets. Do you agree that it's idiotic? The profit that capitalists make on supermarket products is already low thanks to capitalism, so it will not bring down prices. I mean, yeah, personally, I think it's a dumb thing, but I mean, we'll see what happens. But this is. Remember that they described this order as incredibly narrowly tailored. So they're saying this is a narrowly tailored order. And the order is, no person covered by this order shall make or cause to be made any public statement, including on live streams, podcasts, social media platforms, blogs, or to the press that disparages, harasses, threatens, or intimidates the parties, witnesses, potential witnesses, or either party's counsel. Oh, okay. What does that even mean? What is a potential witness? Like somebody named in the like pre-trial disclosures? Publicizes or repeats any sensitive personal allegations or private details underlying the claims of this action. What does that even mean? I can't even talk about the subject matter of the court case? Like, publicizes or repeats any confidential settlement discussions or communications which are protected, they're not protected under this, or any meet and confer communications with counsel. What, so I can't bring up the fact that she was, threatening to kill herself if I didn't pay her off? Or that they were asking for $15 million from me initially? Publicly identifies the plaintiff or witnesses whose declarations have already have been filed under seal or speculates about the identity of witnesses or potential witnesses, particularly in derogatory, demeaning, or inflammatory terms. So I can't even say if I think somebody's lying. I can't say that like the allegations against me are false. This is not true. What? Misrepresents or mischaracterizes the content of legal filings, discovery, court orders, or the position of any party or attorney. Wait, what the? This is supposed to be narrowly tailored? This is basically a 100% gag order. Like, so I just can't say anything at all about the case anymore. Like, that's basically what this is looking at. To call this narrowly tailored is insane, but okay. Okay, sorry. That was the first meme. And then the second meme is, oh, I think we filed to have the one, the Abby MC shit, completely tossed because it was just for, I don't remember. I have to go back and reread. It was a ridiculous submission, but is that their proposal for a gag order? Basically, yes. They call it a protective order, but that's basically what it was. Plaintiff Jane Doe's reply in support of motion to file redacted evidence in support of the declaration of Abby MC and for leave to file under seal. So, first of all, when they filed Abby MC's retarded declaration, they should have attached the evidence to it. I don't know why they didn't. They probably didn't even have it at the time because they don't give a fuck if any of the people talking to them are even making real allegations against me or not, which is evidenced by the fact that they were relying on DMs from people whose identities they hadn't even ascertained before filing the fucking complaint, and then groveling in front of the judge for a temporary restraining order 2 months after filing the case, and then trying to blame their cancer treatments on their late filing. It's just so ridiculous. Don't take the fucking case. If you can't balance chemo and motions at the same time, why you like, I don't even know if you're competent to practice at that point, but whatever. Defendant's attempt to strike the evidence corroborating the declaration of Abby MC reeks of desperation. The evidence corroborating? This is not a corroboration. This is her initial claim that should have been included. It's not corroborating evidence to include a text message. Also, by the way, just to be clear, this is the evidence that she submitted to that she gave to the attorneys. By the way, Destiny sends me sex tapes all the time, and he thinks, I don't know, the girl's in them, but I have videos of him fucking Cherry and Pixie, like Limfeo. He just sent me another one. Haven't opened it. Let's see who he's fucking this time. He should be more careful, basically. Limeo. This is the totality of the evidence that this person has, that I've ever sent them anything, which I haven't. Because another thing they admitted in the hearing, that they said very clearly, I think on 2 different occasions, was this person never gave them any evidence whatsoever that I actually sent her anything. There was no evidence of that ever submitted, ever. They admitted that they hadn't seen evidence of it at all. And I also know this is the person who I showed was apparently taking pictures of my fucking computer when they were at my house. So I don't even know what they've seen or haven't seen on my computer or what, because like this video doesn't even exist. This isn't even a real thing. This is not even a real thing. Also, I like how they also edited part of a redacted filing too. What, you couldn't redact the person's message, but this is the totality of evidence that this person has. It's like this, in case you're not aware, this is the one thing right here. This is the entire case is built on this one message. The entire motion for summary judgment that we're filing, right, on whether or not the case will get tossed, whether we have to actually go to trial, all of it will come down to whether or not the judge thinks that this is a factual dispute that would need to be settled in a jury trial. It will all come down to this one singular message. I don't know how judges ordinarily rule on evidence stuff like this, but y'all should depose Abby MC, you mean? Because I don't know who the other person is. Yeah, maybe if it gets that far, maybe we'll do a deposition. Does the judge differentiate between loaded words and their actual meanings? Like when you say corroborating? Oh, I don't know. I'm just saying that like they're acting like they're submitting more and more evidence that's corroborating this person's statements, but it's not corroborating evidence. This is just the text message that they referred to in their first declaration. It should have been submitted with her declaration, but I don't know why they didn't. I thought you tried to serve them and they couldn't be found. Yeah, we're trying, but that text doesn't even prove you sent the Pixie one before October 2022. You mean after? Yeah, no, it doesn't prove anything. And like I said, I've gone through my messages with this person and I haven't done, it's just not true. The person is lying. It seems like there's just an endless back and forth of filings between plaintiff and defendant. When is there going to be any rulings by the judge? Well, these motions should be ruled on soon. And then hopefully we get something from the magistrate judge soon relating to the preliminary injunction. But like judges are busy. They're not going to be like proofreading every single motion or going through all this bullshit, yeah. Do they need proof of this part of the trial? Well, I mean, you could argue that their proof is her testimony, right? The proof would be her saying, he sent me those videos. And so, I mean, if it was a very conservative judge, again, I don't know what the standards are, like the strict standards are for summary judgment. Like an incredibly conservative judge, I guess, could theoretically rule and say, well, this is a material fact dispute, and it's not up for the judge to make a ruling on that. So then the entire trial would basically be putting Abby on the stand and then having her testify. But she must agree to be deposed and answer any questions before MSJ. Oh, motion for summary. Oh, maybe that's true. Maybe if she refuses to be deposed, then maybe it gets tossed, I guess. What would be the reason for you to not show publicly all the DMs with this person? Because technically, why not? Wait, was there a reason for this? Oh, I don't know if it would count as like revealing the person or whatever. So I don't even know if I would need to. Also, I'm not dumping my whole DM history. It's fucking gross. But I mean, like I said, like I went through and I looked at the particular date and I know which 2 videos I was talking about. Both of them refer to, I know exactly which 2 videos were, and it was nothing to do with this complaint or any of the people involved in this complaint. It's nothing related to that. Like I know exactly what they were when I was referring to on that date. And this person probably should know as well. Like you can even tell by reading their responses to me that they know what it was. So this is just it's a total fucking lie. But I think that this person is, I could say a bunch about them, but they have their own set of problems. But defendant's attempt to strike the evidence corroborating the declaration of IBMC reeks of desperation. See defendant's opposition plan. Blah, blah, blah. For months, the defendant has been gloating on his platforms to his hundreds of thousands of followers that despite his heinous acts, he will not be held accountable because he allegedly shared the video prior to the effective date of Cardi. No, I have not said that I think anything wrong happened or that anything was done, non-consensually, whatever. That would be an argument that we could have if they had subject matter jurisdiction. But the first argument we're going with is, of course, is you're trying a case that you don't even have the authority to file in federal court. You chose to file in federal court, and you chose to file under the statute, and you chose to deliberately lie in the filings. 1, claiming that you had evidence from people that didn't exist or that you hadn't gathered evidence from, and 2, by lying and misstating the date of a submitted text message in order to bring it in range so you could file this in public court, in federal court, so that you could have your fun day parading around on the internet like you meant something. So that's on you. Sorry. Indeed, to date, defendant's entire defense has hung its hat on this alleged lack of subject matter jurisdiction. That's wrong, and that's a lie. But I can't read the court transcript where we talked about this in front of the judge, so I guess you got me there for now. But despite defendants' harassing and threatening commentary intended to prevent witnesses from coming forward on plaintiff's behalf, a brave witness did come forward and provided a declaration evidencing that defendant shared the video with her after the effective date of Cardi, thereby defeating defendant's only defense. Okay, that's not my only defense, but even without the IBMC testimony and evidence, however, there are strong legal grounds for finding subject matter jurisdiction under, inter alia, the ongoing distribution doctrine. So there's another Kiwi Farms argument where they're saying, well, if you send a link to a thing, technically you're always continually and forever sending it. But again, my counter argument there is that means that every single thing you ever send ever is always being continually forever sent. That would be true of every single digital platform ever, which is stupid. I've never seen a court case ever that uses this standard to determine ongoing distribution, but they're welcome to cite one if they can find it. Although actually, I think in the hearing, I think they admitted that they had zero case law to back that claim up as well. Defendant's opposition relies on false and misleading statements, a mischaracterization of the evidence, and inapplicable case law in its futile attempt to strike the corroborating evidence. The very premise of the opposition is false. The evidentiary hearing on plaintiff's motion already occurred. Now, on the eve of the court issuing a ruling on her motion, plaintiff seeks to submit new and untimely evidence in support of her motion, depriving Bonnell of an opportunity to respond or to challenge the declarant in open court. The actual facts are that 1, IBMC's declaration was submitted on May 2nd, 2025 in support of plaintiff's reply to opposition to motion for a preliminary injunction. Yeah, but not her actual text message. How are you allowed to talk about stuff in the hearing when it is sealed? I mean, it's just the transcript that's sealed. I should be able to talk about the hearing. I was there and it was public. It was a public hearing. The only thing that's sealed is the transcript. 2, the declaration specifically referenced and quoted a text chat thread in which IBMC told her friend that she had just received a sexually explicit video of plaintiff from Bonnell. 49-2. I don't even remember what her original thing looked like. Wait, does it quote anything here? I told my friend that Destiny sent me another video of him and another woman that I recognized as the streamer with the screen name Cherry. That's not even what she said. It doesn't even match the additional stuff that she filed. She said that I told my friend that Destiny sent me another video of him and another woman that just another person. So she doesn't even accurately summarize. I'm not going to say anything or whatever. Maybe like her affidavit here doesn't even match the text messages that she submitted. But okay. The declaration specifically referenced and quoted a text chat thread. I don't see any quotations here or quote marks unless I'm missing something. But okay. Maybe quoted means something different to them. The evidence is not new, but rather is evidence corroborating Abby MC's declaration in the form of a screenshot of the referenced and precisely quoted text chat thread. The evidence was submitted before the June 3rd preliminary injunction. I like how they don't put the date that they submitted this evidence, but they do put the date they submitted her original declaration. The June 3rd preliminary injunction hearing, by the way, the evidence that they submitted of her corroborating text message was on June 2nd, by the way. But okay, good one. What is the, wait, it was this? Sorry, it was this. Sorry, it's annoying because like, it seems like I'm being a stickler here, but remember, this is the only piece of evidence that is keeping this case alive. They know it. This is why they are desperately trying to salvage what they know this is a lie, but they're desperately trying to salvage this. And it's just irritating that they're not even summarizing their own evidence correctly, right? So they say that the declaration specifically referenced and quoted a text chat thread in which Abby MC told her friend that she had just received a sexually explicit video of plaintiff. Wait, did I just misread this? What's okay? The declaration specifically referenced a quoted text chat thread in which Abby MC told her friend that she had just received a sexually explicit video of plaintiff. Oh wait, no, even this is not correct. Wait, I don't even know what the fuck I'm reading anymore. I'm sorry, hold on. The declaration specifically referenced and quoted a text chat thread in which Abby MC told her friend that she had just received a sexually explicit video of plaintiff from Bonnell. So that's not true. She says, by the way, Destiny sends me sex tapes all the time, and he thinks I don't know the girls in them, but I have videos of him fucking Cherry and Pixie, like Limfeo. He just sent me another one, haven't opened it. Let's see who he's fucking this time. So this text that they're summarizing here doesn't even accurately summarize this, number one. And then number two, her declaration doesn't even match her own text thread here, because she says, on or about November 3rd, I messaged a friend of mine and told him that Destiny had sent me the above-mentioned sexually explicit video of himself and another woman, and that I had recognized the woman as the streamer Pixie. I also told my friend that Destiny had sent me another video of him and another woman that I recognized as the streamer with the screen name Cherry. I was able to recognize Cherry just by her voice, and since the video was a black screen with audio of their sexual interactions, I retained in my possession a copy of them. But that's not even really what she said here. She said that I had sent her tapes of Cherry and Pixie, and then I sent her something different this time. So her own declaration doesn't really match the submitted text message here, the two messages that we see with no other context around it or anything else. I have no idea who these are to or what this is in reference to. And then their summary doesn't match their newly submitted evidence, nor does it even match her declaration. Okay, sorry. Anyway, it's just, but whatever. The evidence is not new, but rather is evidence corroborating Abby MC's declaration in the form of a screenshot, blah, blah, blah. The evidence was submitted before the June 3rd preliminary injunction hearing. And 2 and 5, Bonnell could have subpoenaed Abby to testify at the hearing, but he did not, thereby waiving any objection to her declaration. I think we've tried to subpoena her, but we can't get a hold of her. Like they're not accepting service on her behalf, and we can't find her anywhere right now. So, okay. The evidence at issue is not new and was timely submitted. Defendant mischaracterizes the corroborating evidence submitted as new and untimely. In reality, the text message plaintiff seeks to submit was explicitly referenced in paragraph 7 of the declaration, but it wasn't explicitly referenced. There are no quotes. There is no quotation mark here for anything. This is at best, it's a summary of this message. It doesn't even match the content one-to-one of the message. And again, we're in a court case, so it's kind of important that you're being specific with your words. So, whatever. Which was filed on May 3rd, 2025, well before the evidentiary hearing held on June 3rd. The evidence is therefore not a belated submission, but rather documentation corroborating a declaration already in the record. Courts routinely allow such corroborative exhibits, especially where they support previously submitted declarations and relate directly to evidentiary matters under review. Unlike in Butler v. Garland, plaintiff is not attempting to reopen the evidentiary record or offer post-hearing supplemental declarations. Instead, plaintiff merely filed they keep calling it corroborating but oh, whatever. Material that reinforces previously submitted evidence already before the court, all filed prior to the hearing, the day before the hearing. Defendant's reliance on Butler is misplaced and said has no relevance here, where ABMC's declarations and corroborating evidence were submitted prior to the hearing. Ironically, on May 30th, defendant objected to ABMC's assertion in her declaration the defendant sent her the video because she provided no support for this baseless contention and failed to attach any exhibits reflecting the alleged transmission of the video. In response, plaintiff submitted the corroborating evidence of her text message. Why wasn't that included with the original filing, number one? And number two, there's still nothing that has to do with transmitting any videos to her. But defendant further argues that because plaintiff had notice of a jurisdictional challenge, the evidence had to have been presented at the hearing or else risk waiving the right to present such evidence. This, of course, is nonsensical because the court never said it would only consider evidence presented at the hearing. The briefs and supporting evidence submitted prior to the hearing are also part of the preliminary injunction record. Also, neither of the cases relied on defendant's contentions that the evidence is new and untimely. Defendant's evidentiary objections lack merit. Defendant argues that the corroborating text message is inadmissible hearsay and unauthenticated. However, such evidentiary objections are premature and misapplied in this context. The court may consider hearsay in preliminary injunction proceedings, particularly when it supports testimony already presented via declaration. Preliminary injunctions are customarily granted on the basis of procedures that are less formal in evidence, that is less complete than in a trial on the merits. All well-pleaded allegations in the moving party's complaint and uncontroverted affidavits filed in support of the preliminary injunction motion are taken as true. Uncontroverted, meaning we don't contest them, no? Isn't that what uncontroverted means here? Furthermore, in reviewing a preliminary injunction motion, a district court may rely on affidavits and hearsay materials, which would not be admissible evidence for a permanent injunction, if the evidence is appropriate given the character and objectives of the injunctive proceeding. Did the magistrate judge say anything in the hearing about the fact that Jane Doe submitted these exhibits on the day before the hearing? No, we brought it up a couple times, but they kind of stayed away from the, they didn't really touch much on the ABMC stuff. It's just, you know. Furthermore, in reviewing a preliminary injunction motion, a district court may rely on... The exhibit is consistent with ABMC's declaration and includes metadata and contextual cues sufficient to support its probative value. The text message dated November 3rd, 2023 directly corroborates paragraph 7 of the declaration. The defendant transmitted a sexually explicit video of plaintiff to her. How does that... the date corroborates that I sent them a video? In what world does every... Okay. Defendant's claim that this message lacks probative value is contradicted by his own recognition that it supports plaintiff's jurisdictional arguments under the Carty statute. Defendant has failed to present any valid reason for the court to disregard or strike the declaration or the corroborating evidence that ABMC's declaration and the corroborating text message are properly before the court for purposes of the preliminary injunction determination. ABMC's non-testimony at hearing does not warrant exclusion. Once again, defendant is litigating in bad faith by deliberately distorting the facts. Defendant asserts that Abby failed to appear to testify at the hearing and that ABMC refused to appear or testify at the preliminary injunction hearing, but defendant knows that neither he nor plaintiff requested ABMC to testify, and there is no evidence to support his spurious assertion that ABMC refused or failed to appear. Defendant also deliberately attempts to mislead the court by stating, plaintiff's counsel refused to accept service of a subpoena on her behalf. ABMC has thus far avoided personal service. Defendant did not provide any evidence in support of these spurious assertions, nor can he. This is because the referenced request was on May 15th, 2025 for a subpoena to produce documents, not for ABMC to testify at the hearing. Moreover, plaintiff's counsel never refused to accept service. Instead, less than 24 hours later and before counsel could respond, defendant's counsel said he would proceed to serve ABMC himself. What? And then they didn't respond to it? Defendant has not provided any evidence of attempts to serve ABMC, and there's certainly no evidence she's avoiding service. How do you have evidence that somebody's avoiding service? How do you even do that? I can't publish emails or whatever, but records of dates and times you attempted to serve. Oh, maybe if they use a service provider, I wish they might have. Maybe that'll show up in another filing, I guess. Plaintiff has no obligation to call every declarant as a witness for the hearing, and the record is clear that defendant did not seek to call ABMC either. Defendant chose not to subpoena or depose ABMC in advance, despite having notice of her identity and the substance of her declaration a full month prior to the hearing. The court's order scheduling the hearing did not state that all witnesses needed to testify in person or that the declarations and other evidence submitted would not be considered. That is true. She didn't need to be there. That is true. But you would imagine that you would want your solo witness that is holding your subject matter jurisdiction to be there. You would imagine that, but who knows? Who cares? Courts do not require personal testimony from every declarant, where the written declaration and supporting evidence have been timely submitted. Technically, I don't even know if either of us needed to be there. I think technically we both could have skipped it, but I don't know if anybody's required to be at that hearing. I'm not sure. I'm not 100% sure on that. Although affidavits are ordinarily inadmissible at trial, they are fully admissible in preliminary injunction proceedings. Defendant's argument that he was denied the opportunity to cross-examine Abby MC is baseless. Defendant had over a month's notice of Abby MC's declaration and its contents, but failed to issue a subpoena, notice a deposition, or otherwise secure her attendance at the hearing. The corroborating evidence of the text message presented nothing not already in the declaration, and thus does not change the fact that defendant had a month's notice. Plaintiff was under no obligation to call every declarant, and defendant's strategic choice not to compel Abby MC's testimony constitutes a waiver of any objection to the court's consideration of her declaration or the corroborating text message. Defendant did not object contemporaneously, nor did he move to strike the declaration. His silence and inaction constitutes waiver. A party cannot remain passive and then claim unfairness when the record closes. As a final matter, plaintiff notes that the defendant had not objected to that portion of the motion requesting that the unredacted version of the exhibit be filed under seal. The exhibit plaintiff seeks to submit is not new evidence, but it's merely corroborative declaration. Okay. Jesus Christ. You kind of skipped the last part. What does that mean? What does what mean? What last part? The last part was just a conclusion or summary of why is all this shit so slow to have anything happen? It's court. It takes a while. This is just the summary of everything that was said. Did you reach to subpoena her? Yeah, we've been trying to, but initially, they said that they were representing her to sue me, and then nothing came of that. And I think we requested to do something through her lawyer, but then they said that they're no longer, they don't represent her, so they can't accept, or I don't know if they said specifically they don't represent her. They said that they can't accept service on her behalf. And then apparently been trying to serve her, but we can't find anywhere to serve her for documents. So Destiny, chances of it getting unsealed. It should be unsealed. It should be. We just have to wait for the judge to rule on it. My understanding is there's like no basis and no world where that actually happens, where the judge would allow a public hearing to retroactively be sealed like that. We have to fight for every hearing to be public. I don't know. Who knows? If it's sealed, does that mean you can't even talk about it from your own memory? Yeah, I can talk. I'm pretty sure I can talk about it from my memory of what have happened. But I wanted to. It would just be nice to read the actual transcript. Do you have to wait until December for summary judgment? I think you can file summary judgment anytime you want in the discovery phase, but it's best to wait for most of the stuff to be in. So, okay. What are the chances that anyone who talked on the situation takes down their video or at least addresses the new changes later on down the line? Probably super unlikely. Who knows? I don't even know how it'll, because I think because some people are trying, the narrative is shifted over and over and over again based on how retarded plaintiff looks. And now that they look super retarded, like every 10 IQ point drops, there's like a new narrative. And right now the narrative is just that if I win, it's on a technicality, or some people are, even a lot of you guys are doing, they're like, oh, well, they both did something really wrong. And it's like, no, or we just had an understanding that plaintiff is misrepresenting because she's basically paying that she got outed as streamers. But who knows? We'll see. I think this is our final brief before we wait for the judge to rule on a bunch of things. How long do you think it'll take to rule this up? Hopefully within a couple of weeks, I think is the expectation. Plaintiff Jane Doe's reply in support of motion to have June 3rd, 2025 evidentiary hearing transcript filed under seal. Comes now. Plaintiff Jane Doe, by and through undersigned counsel, and hereby submits her reply in support of her motion to have June 3rd, 2025 evidentiary hearing transcript filed under seal, and respectfully states as follows. Introduction. Defendant's opposition, ECF 101, distorts both the record and the applicable legal standards and reveals that his only interest in opposing sealing is financial and performative, not rooted in any public right. Like I don't have the public right to have a public viewing of my court stuff. Good one. But plaintiff does not seek to shield herself from embarrassment or scrutiny, as defendant suggests. Interesting. Rather, she seeks to protect deeply private, sexually explicit, and mental health-related testimony from being broadcast to over 1 million online followers by a political streamer who has a documented pattern of weaponizing public proceedings for harassment, monetization, and spectacle. That's crazy, given that she's the one that filed a public case and also, prior to this, made a public Substack that was full of a whole bunch of lies. I was going to say speculation, but not even. Just she knows they're fucking lies. But okay. Defendant has, throughout the case, used his platform to publicly attack plaintiff, her counsel, and even third-party witnesses. Just keep repeating the same. I wonder if there's going to be in like every single filing that Justigal and Queeman are third-party witnesses. I wonder if they're just going to repeat this over and 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 over again. See ECF number 73, blah, 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 blah. If the transcript is unsealed, I don't even think it's technically sealed. I think it's like it is sealed, but it's while the judge is going to make a ruling. So we're not really asking, I don't think, for it to be unsealed, but to deny their motion to seal. If the transcript is unsealed, it is all but certain that it will be publicly read, mocked, and monetized online in ways that will inflict real and irreparable harm. I'm sorry, if your under oath testimony is mocked, I mean, that's on you. Well, I mean, what do you mean? This is again, it's like they want to have like a private Discord call, but they want to pretend it's court, or they want to go to court and pretend that they can treat it like a private Discord one-on-one call. If you want to sue somebody publicly and you want to do public filings and all these things, then that's fine. We can do that, but you can't have this stupid double standard. Indeed, defendant has already explicitly stated that he will read the transcript out loud on his platform if it is unsealed. Yes, I will indeed go over my publicly available, publicly accessible filings for the court case that plaintiff initiated. Is that a problem? How unconfident are you in your own under oath testimony that this is such a threat to you? At minute 12:09, this hour-and-a-half video is solely about the June 3rd hearing. It was filmed on June 3rd and posted on June 4th, 2025, and to date has 353,981 views. Magistrate Judge Torres, who presided over the June 3rd hearing and heard the testimony, readily granted plaintiff's motion to seal the transcript. I'm not aware of that. I believe that the transcript was sealed while they were awaiting a hearing on the motion. I don't think this motion was ever granted, but I guess we're going to go read the exact language. ECF 91. Paperless order granting in part 88 motion to seal. We direct the clerk to maintain the transcript at DE 90 as fully sealed pending further order of the court. So this is just, it's sealed while the magistrate judge is making a ruling on it. But we can also just lie, I guess. It's fun to just lie. Defendant has provided no legitimate reason to unseal the transcript, nor is there any. Okay. Plaintiff's privacy interests outweigh the public interest, thus there is good cause for sealing the transcript. The common law right of access may be overcome by a showing of good cause, which requires balancing the asserted right of access against the other party's interest in keeping the information confidential. In this case, they vacated the lower court's order unsealing documents because it erred by applying the heightened standard of compelling interest rather than merely good cause. Their documents sealed. The content of this transcript, combined with the defendant's highly unusual use of his public platform, meets the standard easily. Now, keep in mind, plaintiff decided, who filed under a Jane Doe, to publicly inform the entire world about my revenge porn being leaked online, and then in multiple court filings has directed everybody to websites to find it. But thank you. Okay, yes. My highly unusual use of my public platform. Thank you. Courts are especially protective of sexual privacy and mental health testimony, two topics directly implicated in the transcript. The defendant conflates the applicable standard and relies on inopposite precedent. The opposition asserts that heightened scrutiny and a compelling government interest are necessary, relying on Globe newspaper v. Super. That was a criminal case, and the standard is not applicable to a civil case. Defendant also erroneously contends that the records should not be sealed absent extraordinary circumstances. Opponent relies on Doe v. GA's Department of Corrections for this contention, but Doe says no such thing. Moreover, Doe is distinguishable because it is a case pertaining to conditions of prisoner confinement, and it is undeniable that the public has a powerful interest in the non-identifying information involved in these proceedings. There is no I haven't read the underlying cases up here. I've only read one of these underlying cases. Also, yeah, for sexual privacy, like Doe, Pixie already made a public post on everything, and it's posted to this day, like on every, so I don't know what, but okay. Here, plaintiff's claims are based on her right to privacy, you, and as the defendant is well aware, the transcript at issue includes testimony about plaintiff's private mental health history? No, just about stuff concerning this, which she's already made public. Details that could lead to her identity? No, that's not true. Intimate sexual communications shared in confidence? This stuff is already all publicly available online. And testimony about sexually explicit content unrelated to the statutory liability issues. I don't even know what that is in reference to, but okay. The subject matter of the transcript is traditionally considered private, not public. Yeah, if this was true, then why didn't they should have moved for this to be a private hearing instead of a public one. But in determining the weight to be accorded an assertion of a right to privacy, courts should first consider the degree to which the subject matter is traditionally considered private rather than public. Financial records of a wholly owned business, family affairs, illnesses, embarrassing conduct with no public ramifications, and similar matters will weigh more heavily against access than conduct affecting a substantial portion of the public. I haven't read this underlying case, but I'm almost certain that this probably pertains to like discovery and stuff that's not like central to the actual court case. But I'm too lazy to go through this. So, and every other, it's like every time they cite cases are just fucking horrible. But foremost among the competing concerns that a court weighing disclosure must consider is the privacy interest of the person resisting disclosure. Courts consistently recognize that sexual and mental health information is considered private and not public, justifying sealing, especially when public disclosure would serve no legitimate function, but instead expose the party to stigma and harassment. Would serve no legitimate function? Excuse me. Stuff that happens in court is presumed to have public access, and there's a huge right of presumption of public access. I don't have to say that there's a legitimate function. That's assumed on my part. You are the one that has to overcome a significant burden there to prove that it should be closed. But, and they even say here presumption in favor of public access. Here, the testimony in the transcript does not concern public officials, nor does it affect public concerns. Thus, there is limited public interest in allowing public access to the transcript. It concerns my court case. What? Whereas plaintiff's interest in sealing the transcript and protecting her private sexual and mental health information is high. You already made a public fucking case where you talk about all this shit. Like, what the fuck? The nature and degree of the injury weighs in favor of sealing. The nature and degree of injury must also be weighed. This will entail consideration not only of the sensitivity of the information and the subject, but also of how the person seeking access intends to use the information. Commercial competitors seeking an advantage over rivals need not be indulged in the name of monitoring the courts, and personal vendettas, similarly, need not be aided. This is not a personal vendetta, though. This has to do with a public civil court case. It's not just a personal vendetta. It's so stupid. Defendant purports to be opposing the sealing of the transcript out of concern for the common law right of public access, but it is transparently obvious that he wants the transcript to be public only to serve his own personal interest. Part of the public right of access is for the personal interest of the people involved in the court case. Yeah, no shit. When I talk about like habeas corpus, well, it seems like they really think that people should be read charges when they're arrested and not just secretly arrested. But it seems like he only wants that so that it doesn't happen to him. Yeah, no shit. What the? Yeah, no shit. Yeah, duh. Yeah, of course. It is beyond any doubt that if the transcript is unsealed, defendant will publish it on his live streams and also read it out loud for the merriment of his hundreds of thousands of followers. Yes, it's a court case. Public, you wanted to file a public case against me. All of this is a public court case. All of this is public. The access to all of it is public. And there has been ample evidence presented to the court of his hours-long discussions of the details of this case on his online platforms, including threats, harassments, and ridicule of plaintiff, witnesses, and counsel. I have not threatened or harassed plaintiff. I have the right to ridicule everybody involved, of course. What do you mean? I'm not allowed to say anything while these people are ridiculing me? That's such a stupid contention. The Nixon court expressed particular concern about protecting from purely prurient interests the display or disclosure of otherwise embarrassing private or familial information obtained through the courts. Purely prurient interest. Again, this is just whatever. It explained that the common law right of inspection, though undoubtedly powerful and never lightly subordinated, must give way where records are sought merely to gratify private spite or promote public scandal through the publication of the painful and sometimes disgusting details of cases. This isn't a private spite. This is a public court case. The Merlis court, I did read this underlying case, reversed the lower court's decision to unseal a judicial document precisely because the lower court failed to consider the motives of the party seeking to have the document unsealed. Courts should consider personal motives, including an applicant's desire to pursue an individual vendetta at the third balancing step of the inquiry in connection with any asserted privacy interests. This case, this is a again, I don't bother reading all the citations because they're so fucking stupid. This case is insane because what the court rejected here, so Eliyahu, Merlis, this person sued Daniel Greer, who was a rabbi, for sexually molesting him. There was other testimony that was brought in. So it was a non-party witness. So they weren't part of this original case. They were a non-party witness in a 2016 civil lawsuit in the District of Columbia. In that suit, the plaintiff, Merlis, a former student at a religious school in New Haven, Connecticut, accused the defendant, Daniel Greer, the former religious leader of that school, of sexually abusing Merlis when Merlis was a minor and a student there. Merlis sought damages from Greer for that abuse in connection with those proceedings. So Merlis here was suing Greer, okay? In connection with those proceedings, Another person, not a party to the case, another person, gave a video recorded deposition lasting several hours in which he testified in detail to having also been a victim of Greer's sexual abuse several decades earlier when Hack was a minor and a student at the school. Hack further testified in his deposition that he'd known Greer's abuse of Merlis, which occurred when Hack was an adult and employed at the school. A transcript of the deposition is publicly available, but public access to the video recording itself is the subject of this appeal. So the transcript exists. This guy, this Dressler guy, wasn't even a part of the court case, and I don't know why, but he was trying to make it so that that deposition would be released publicly, the video of it. After trial, Lawrence Dressler, the interested party appellee, in the appeal now before us, sought the DC's leave to access the video recording of Hack's entire deposition. Using the screen name Larry Noodles, Dressler had written voluminously on his blog about the trial and disparagingly about both Hack and Greer. He informed the court that he sought to copy the video so that he could post it publicly to his internet blog. So this guy isn't even a fucking party to the case, and he's trying to get a video of a witness in this case, who's also not a party to this, but a witness to this case, where the transcript already exists, and then the court said, no, you don't need access to that video. We're not going to give you that video. And they're trying to compare that request to my request. The Merlis court reversed the lower court's decision to unseal the judicial document precisely because the lower court failed to consider the motives of the party seeking to have the document unsealed. The person seeking that transcript, that deposition, the video deposition, wasn't even a party to the fucking case. And the witness here wasn't a party to the case either. Like, it was also in a different district as well. Yeah, this is a second district case, not a 9th district case, but it's just like such an this information is relevant particularly when an individual, and not the press, seeks public access to sensitive information. It wasn't a party to the case. Here, defendant is not a typical litigant. He is a professional online streamer whose income is largely derived from publicly discussing controversial topics, including this lawsuit. Scumbag, subhuman degenerate, acting like I've made more money covering this than I wouldn't have otherwise. But since the outset of this case, defendant has repeatedly posted about it on his streaming platforms, mocked plaintiff and her legal team, and weaponized court filings for online content. Weaponized court filings? Or I'm sorry, I'm in the 11th Circuit, not the 9th, my bad. 9th Circuit is California and Washington and Oregon. How I'm weaponizing my court filings by reading them? Defendant has also publicly ridiculed plaintiff's mental health, sexual history, and witnesses who supported her case. I'm allowed to have an opinion about these things. No one is targeting anybody. No one is threatening anybody, except they keep trying to throw Driscoll and Queeman in, who aren't a part of this case at all. But this is not speculative. His pattern of commentary is well documented and includes live streams, tweets, and reposts designed to stir harassment by his audience. This is also like kind of a little bit like in support of their gag order. So like I just am not allowed to talk about this at all. Obviously, I'm going to say you're lying. I believe you're lying, and we have a disagreement of fact here. That's why there's a court case at all. So like what? Also keep in mind, all of this is buoyed so heavily by the fact that she made a public Substack post with an unhinged list of calculations. I'm sorry, I just read a thing in chat with an unhinged list of accusations against me before even filing the court case. Like, how could you possibly gag me against all of that? Indeed, defendant's only plausible reason for opposing sealing is his interest in continuing to exploit the transcript for personal profit and performative harassment. For this reason, the transcript must remain sealed to prevent further and additional harm to plaintiff. Imagine being so harmed by your own words. Under oath, by the way. Defendant contends, without any legal authority, that plaintiff waived her right to have the transcript sealed because 1, there were members of the public present, and 2, plaintiff did not request sealing until the day after the hearing. First, defendant grossly overstates the public nature of the hearing. Defendant falsely, we've got bold and underline, asserts that multiple individuals unaffiliated with the parties were present in the courtroom gallery, some of whom took contemporaneous notes and later published detailed summaries online. I don't remember if there was... I thought there was more than just one person. My fan in the back, he might have been the only one. I thought there was another person. I don't remember though, because I'm not looking behind me all the time. Opposition P7, page 7. And again, members of the public attended the hearing, took notes, and later discussed the proceeding online and in various public forums. Discussed the proceedings online and in various public forums. Oh yeah, multiple. Some might have been staff or not. I'm not sure. I don't know. But in fact, only one individual sat in the gallery, an associate of defendant with the screen name Zip. An associate? That's just a fucking lie that's being proffered with no evidence and no proof whatsoever. But okay. And his name isn't even Zip, but no press were present. The proceeding was only discussed online by the defendant and Zip on defendant's streaming platform. The video stream makes it clear that Zip was the one taking the notes at the hearing so that defendant could rely on them for his live stream. Okay. I've never... like I didn't even know the guy at the fucking hearing. I didn't even know it was one of my fans. Zip, have we ever communicated before? I think the very first time we've ever communicated was when I was leaving the courthouse and he said that my coat was messed up in the back. It's the first time we've ever communicated in our lives. Are they even trying at this point? What they're doing is they copy paste stuff. I wish I was joking. And nobody will speak out about this because everybody in all of my surrounding X communities are spineless fucking cowards who infinitely not condescend to, but treat white crying women like actual children. All they do is just copy paste stuff from Kiwi Farms and then just put it in a court doc. That's literally all this case is. Hoping to survive summary judgment and then hoping to further malign or embarrass me or reputation tank me or whatever. That's the only, and then waste my money. That's all this case has become. The video stream makes it clear that Zip was the one to, the article referenced in the opposition as support for defendant's false statements was based solely on defendant's video stream and included a link to a portion of the stream. The author of the article has acknowledged that he was not in the courtroom and that the reporting is based explicitly on the video clip that is also attached in the article from Destiny himself. I like that they don't even try to upload stuff on their own or they literally just link directly to a Kiwi Farms video. Like it's just, they're literally just pulling this. Also, it was one of the people on my thread on Kiwi Farms that apparently emailed and wrote to the guy who linked the article. But I like that this is, I think, is this third court doc now where they've just linked directly to a Kiwi Farms thread? But it's actually gross what Pixie's lawyers are doing. No, it's gross what she is doing. Don't blame it. It's not just the lawyer. She's not a fucking child. This is her representation. She theoretically has to approve these things that are being posted online. And she says that she wants to go to law school and whatever she can do with her 75 LSAT. In fact, the article was later amended to reflect this fact. And the original line was changed to read, Destiny recently shared what he learned through court proceedings that defendants' deliberate attempts to mislead the court should be sanctioned. Okay. Second, plaintiff's failure to move contemporaneously for sealing does not waive her rights, particularly where the emotional distress from the hearing's content and the anticipated misuse became apparent only after the hearing concluded. I like how they accidentally revealed the whole giveaway everything here. They were not happy with how the hearing went. That's the reality of what happened. And this is them saying it explicitly. After they realized that everything that they were trying to float here was fucking bullshit. And when they realized that, oh, fuck, we didn't actually tell Pixie, she has no fucking idea how to speak in court like an adult, and yapped and rambled and said so much retarded shit, a lot of which is incredibly damaging to her case, then they're like, oh, we got to seal this shit immediately. Because a lot of this kind of fucks your, at least the public that you've posted about this. But I like how they say this here. The emotional distress from the hearing's content and the anticipated misuse became apparent only after the hearing concluded. Like, what does that even mean? You didn't think, you thought I was a good person, and then after the hearing, you're like, oh, fuck, he might misuse. Like, it's so gross. Post-hearing sealing is routinely granted in similar situations involving sensitive sexual or mental health testimony, particularly where the threat of misuse or online harassment is credible and imminent. I would disbar people, but I don't know anything about that. If I, similar situations, remember, and they're citing this case that had to deal with a minor being raped by an adult giving a video deposition in a case where he wasn't even a party to the case and wanting to have that video deposition sealed while the transcript is still publicly available. So it's not even remotely similar. Unless they have a different definition for similar, or they just don't do English much, I guess. It's actually fucking insane that they would even use this word here, but okay. Post-trial sealing of a judicial document, a video deposition that was played for several hours during a public trial where party opposing sealing motivated by ill will and intended to publish the video online. I don't even know if I would agree with the term party here. They weren't a party to the original case. They were like an appealee party. It was a new thing. I think it was just an independent guy coming into appeal who wasn't a part of, he wasn't part of this case at all. Did they use the term party? Interested party appellee. Like he became a party just in the appeal here, but he wasn't a party to the original case at all. Is my understanding. I think somebody said online that he's like a true crime blogger or something. What's it called? Larry Noodles? Tell us why that distinction is meaningful for the slow ones like me. Because one, the person requesting this video deposition, it would be like one of you guys requesting a deposition in my court case about somebody else giving a deposition about me in a video form where the text was already available. Like imagine Samantha did a video deposition where claiming that I'd raped her 20 years ago or something, and you or somebody who's not being part of the case, and you want the full video deposition of her testimony. And then the court says, well, no, you weren't even a party to the case. You're literally writing about this with the goal of harassing and mocking her. And it's not like it's not testimony from somebody who's part of the case. This is a deposition that she gave. And the transcript is still fully available online, which it was. So it's like not even remotely, it's like not comparable, like 7 different ways. Yet Dressler, this is the non-party who's requesting the video deposition, Dressler identified no affirmative public need that would be served by general release of the video deposition when the text transcript was already available. Indeed, no other individual entity and no media outlet joined in Dressler's request. The privacy interests of so the whole text transcript was already fully available. This is it's not even remotely close. It's just so stupid. I'm sorry. The Merlis court found that the lower court erred by discounting the privacy interests of the person seeking sealing. The lower court's reasons that 1, the person's testimony had already been made publicly available, and 2, the person failed to request that the deposition be sealed at the time he sat for it, were specifically rejected by the appellate court. This is just fucking bullshit. Similarly here, the court should reject defendant's baseless arguments. Plaintiff's limited public statements in no way undermine a request. Defendant's reliance on plaintiff's limited public advocacy is a red herring. Discussing her case in broad general terms does not waive her right to protect explicit details about her sexuality or mental health from being dissected in a monetized online video. Further, plaintiff's modest online fundraising activity does not equate to publicizing her private testimony. The hypocrisy of defendant's argument is glaring. Defendant, by contrast, is a professional content creator earning revenue by sensationalizing the case. It is just so unfathomably disgusting. Like, sensationalizing the case? Just to be clear from where we came from for this was her public Substack before any case went live. On November 29th, I learned that the streamer Destiny also my full name, Stephen Kenneth Bundles, had non-consensually shared pornographic content of me online. All of this is written to maximize just pornographic content of you. No, it was of us. And online makes it sound like I was the one who published it to Kiwi Farms. So this whole statement is misleading. My dignity, peace of mind, and hopes for the future were stripped away in a mere matter of seconds following the betrayal of someone I previously trusted. I am at least the 3rd person he has done this to. Other people could sue me if they want, and then we'll go through all of that. But obviously, she's adding this in here. It's not even technically her story and tell, but hey, I guess I'm harassing and causing everybody to go into hiding. I hope to be the last. I will not be commenting on the experience of the other women he has hurt, as it is not my place or story to tell, despite the fact that she keeps adding them in court document after court document after court document, when at least one of them is publicly stated, I don't want to be involved in this. I don't know why I keep getting mentioned over and over again, but I will, however, share my story in the hopes of preventing this from occurring again. I have known Destiny for around 5 to 6 years now and often find myself in heavy disagreements with him. Despite this, I do my best to see the best sides of all people, trying my hardest to spread positivity and create understanding where I can. It's corny, but I want to meet people where they are and focus on which ways we can build bridges together towards a better future for everyone. Some people call this a fault of mine. They claim I am naive and should be more careful. These people are right. When I was 19, over 5 years ago, I was extremely sexually inexperienced and sheltered. So she wasn't 19. We started chatting when she was 20 and we met when she was 21. All of these dates are easily verifiable. She still has all the chat logs to this. She, I assume, knows when her fucking birthday was. So why would you just lie about your age? Why would you lie about this? Right? We can just look at the logs. I know when her birthday is and I know when we started chatting. So this is a fucking lie. But I guess we want to be 19 to be freshly 19 or a teenager. I was extremely sexually inexperienced and sheltered. She makes it sound like she's like an actual fucking virgin, whatever. Like, you're literally recording videos with your boyfriend or senator. What the fuck is wrong with you? But like to say this and make it sound like you're some completely, being severely terrified of leading someone on or sexual assault. I thought I could trust Destiny, who I had multiple long conversations with regarding consent and boundaries. What does this even have to do with anything? You didn't get sexually assaulted or led on. Like, what? So you can imagine my surprise when I discovered he distributed pornographic content of me without my consent. Again, distributed what, to multiple people, published it online, content, what, just of you? Like, it is meaningfully different. Am I just sending videos solo of her around, or is it stuff that we've filmed together? Yes, you read that right. Stephen Kenneth Bundles II sent pornographic content of me to a random 19-year-old e-girl Discord kitten whom he had never met before, and then she published it to the whole world. You, by your own thing, now you weren't 19 or 20, but aren't you describing yourself? Like, listen how fucking retarded you sound here. Like, I was 19 and he was sending me videos. Also, he sent videos to another person who was 19. This, by the way, comes up in the transcript in a very hilarious way, but I can't read it. But like, what? And then she published it to the whole world. Rest assured, despite never having met her, he at least spoke to her plenty of times on the phone. Yeah, this was the same relationship I had with you. Like, what is the point of... Of course, This is what he says happened. I think it is just as likely that he used her as a proxy to widely distribute this material while claiming deniability. And I think that she published this because she secretly likes seeing all of it online and she likes the attention from her video. Like, what a fucking unhinged statement to make. I do not understand why Destiny would knowingly and willingly put me in a position where I would receive nonstop sexual abuse and harassment. If we believe him, he was trying to impress a barely legal teenager using my body and my person. If we believe, I've never said this ever, but that's a cool read here. Like, nothing that we filmed was as impressive as this. To like, what a stupid statement. The betrayal, coupled with the hundreds of messages I've received, filled with sexual harassment and abuse, have left me feeling hopeless and devoid of almost all happiness. Wow, you're discussing your mental health and everything in your Substack. Nice. The only thing that has kept me going is the hope that I can bring this man to justice and have him face legal consequences for his actions. For the past month, I've been speaking to lawyers about my situation and what to do, and have decided this is the best course of action. Now, most of the lawyers that she spoke with told her that she had no case. But thank God she has a family friend, I guess, that can litigate against me. So thank goodness for that. I will be suing him for some federal code that Lauren looked up for me, civil action relating to disclosure of intimate images, and for publication of private facts in Florida. I will be seeking emotional and punitive damages for his actions. I have been told that a court case like this could potentially cost over tens of thousands of dollars. I am terrified. I mean, this guy talks about potentially suing Hassan as if for fun, and Hassan actually has the resources to defend himself. I cannot imagine what he might try to do to me in the process. How do you victimize yourself before doing anything when you're literally like sometimes I wonder if he does this as an intimidation tactic. I wonder if he is purposefully trying to put fear into my heart when he casually talks about throwing money into a lawsuit with a multimillionaire who can fight back, as if it's an indirect flaunt/warning over his capability of outspending me in whatever legal case I throw at him. At the request of my friends, I have been encouraged to link my GiveSendGo regarding this case here in hopes that we can raise enough for me to legally succeed. Whoever the next Joe Rogan of the left is, it cannot be someone that crosses sexual boundaries, violates consent, and puts women's well-being and safety at risk. It cannot be someone who puts women in positions where they will be sexually abused and harassed. It concerns me that Destiny's been interviewing potential DNC chair candidates such as Marianne Williamson or Martin O'Malley, who have no idea of what he's done. As time passes and he tries to position himself to have interviews with increasingly powerful figures such as Zelensky, I can't help but be filled with fear that Destiny might continue to succeed despite facing no repercussions for his actions. If the Democratic Party wishes to succeed in the future, it cannot be a party that accepts the sexual exploitation of women. It cannot be a party that allows men like Destiny to break into the mainstream, for allowing him access to such spaces would be a direct endorsement of his behavior. I have been told that the payout might not be worth the harassment and attention I will receive. In an ideal world, I would do this privately, but have been told that there's no realistic way the court will grant me anonymity. Like, did you not even read the statute that you cited? There's a reason why you proceeded under seal. Like, this is more just lies. Maybe she can't even read. Who knows? This means my only, maybe she dictated this. I don't know. This means my only option is public. I have been told by a variety of people not to go public. I have been told by some people that Stephen really does feel sorry, but I am not inclined to believe them, especially taking into consideration his actions regarding me. Regardless, what Destiny did was unacceptable, and I believe he will do this again unless he faces justice. Like, so brave of you to say all this, and then as soon as you have to actually sit your dumbass down in front of a fucking judge and speak under oath, and your testimony changes dramatically, that now you want to seal the fuck out of that while leaving, like, dribble like this online to fundraise off of. Like, it's actually so fucking annoying to me. I hate that. It's so annoying. Defended by contrast for okay. He has mocked and doxed plaintiff supporters and witnesses. Supporters now? What in the fuck is a supporter? Like a friend? Like what? Ensuring that public disclosure of the transcript would lead to further harassment and harm. Indeed, right after the hearing concluded, defendant was streaming on his platform and mocking the plaintiff for having cried while she was testifying. Yes, because you're breaking down in your own examination. This is unhinged. In his chat thread on his personal platform, defendant wrote to his followers that plaintiff had a big breakdown. I started crying halfway through. We had to take a 10-minute break. LOOOOOOOOOOL. He also writes, I'm going to be honest, I got really uncomfortable when she was on the stand and started getting upset because it started to look like I had hooked up with somebody. I thought I said retarded, but maybe mentally ill. This disparaging comment is followed by a laughing emoji. Defendant has provided no evidence of any similar publishing by plaintiff. Like, are you serious? Like, the person who literally accused me of using a person online as a proxy to post like 27 sexual videos of me online? Accordingly, plaintiff urges the court to maintain the transcript under seal. Alternatively, in the event that the court determines plaintiff has not demonstrated good cause to have the entire transcript sealed, plaintiff requests that she be allowed to designate portions of the transcript as confidential and that the transcript only be unsealed in redacted form. I hope they don't grant this in part, because then it's going to be another 30 days to redact And then we're going to probably have to do a brief or why we argue some stuff shouldn't be redacted. And then it's going to be like another 3 months. Like, Destiny, the LOL meme is actually misrepresented. You said that in regard to something else. Also, the messages are presented in the wrong order. Oh, because they go bottom to top. Oh, true. I don't say she had a big breakdown, LOL. I was saying LOL because the hearing was an open court, but they want to seal the transcript from the hearing now, LOL. Lock Knox, she had a big breakdown and started crying halfway through. We had to take a 10-minute break. I think she was getting really frustrated. Oh, true. So they did quite, but they don't care. They don't care about lying in filings, and none of it matters because the plaintiff has no reputation or online anything anyway, and no one is ever going to say anything detrimental about her because it's a white woman tier saying some unhinged retarded about this. So, the message of you realizing it was me at the hearing, meaning you didn't know me. Oh yeah, I like how they try to say that we're. Oh, ZipZip45. Oh wait, ZipZip45, was that you this morning? Oh yeah, because I didn't even know who the f you were. Yeah, but whatever. Plaintiff respectfully requests that the court reject defendant's opposition and grant the motion to seal. Hearings turns the public interest in having testimony involving their sexual and mental health information and identifying data be public is very low, and there is no identifying data in this transcript. And plaintiff's interest in keeping the information private is very high. Do you get to respond to this? Nope. This was their briefing. We already made our briefing, and hopefully within the next couple of weeks, the judge starts ruling on a bunch of these motions. I just hope it's not granted in part because if the redacting is it's just going to be another like 2 or 3 or 4 months to delay everything. How possible do you think it is that she knows her case is weak and her only goal now is to make you spend as much possible? That is 100% what's going on. Obviously, that's what's going on. The Abby MC evidence is, I don't even want to say it's weak at best. They're knowingly lying about that evidence. They're knowingly lying in court. I think actually, it might also be that Pixie might be lying to her representation, and maybe they don't know. So one thing I thought was interesting as I was recalling my thoughts about what was said in court, one of the things that they accuse me of, and Pixie might just be lying to her representation, or she's retarded and forgot, who knows, is they claim that I never actually contacted a law firm in New York. They claim that that's a total fucking lie and that I actually misrepresented that entirely, and I lied to Pixie the whole time about that. Now, they might only be saying that because on Kiwi Farms they say that. They say that I'm lying about ever contacting a New York law firm. However, I can verify that not only did I contact that New York law firm, they know that I contacted a New York law firm because back when Brianna Wu was helping Pixie, I don't know if that's public or not, but Brianna Wu was trying to help Pixie behind the scenes. She contacted the same law firm that I had retained in New York, and they had to reject her because of a conflict of interest. So she knows for a fact that I had retained a law firm relating to this case because she was rejected from that one in New York because it was the same one that I was going to use to pursue my case against Kiwi. So she knows it's a fucking lie, even though they tried to float that in court against me a couple times. But it's, who the fuck cares, I guess. Literally like white woman power. It's unreal, dude. If I was a white woman, I would be the fucking president of the world. Is plaintiff suing the person who posted the video? No, plaintiff doesn't give a fuck about the person who posted the video or the website hosting the video. The only thing she cares about is trying to make a name, taking me down, because she's insanely far left and is being powered by somebody who's insanely far right and has convinced herself this is her last fucking like mission on earth is to take out the evil rapist or whatever. And so this is her life mission until this all ends. Was this illegal? I don't think you ever said that about Brenda helping her. I don't know. I don't remember if I said it or not, but she was helping her initially, which was stupid of Pixie and irresponsible on Brianna Wu's part because there is no attorney-client privilege between Brianna and Pixie since she wasn't retained as legal representation. So theoretically, I can do discovery or subpoena all of those conversations. Not that any of it matters, but good times. Do you feel slighted by all the people who distance themselves from you? They feel awfully quiet, to be honest. No, it's just the white woman power. It is what it is. Do you blame them for not wanting to be associated with you? Yeah, I do. That's why I'm not going back. That's why after this case, I'm done with. That's why I blocked them all. Said, fuck it, we move on.